Hi, Tony DeWitt here, Missouri Appellate Attorney and a guy who likes to make the law make sense on YouTube. This is what we're discussing today. This is another of those lawyers behaving badly, and again, it's a Missouri lawyer, but this time we're at the Missouri Supreme Court, and the level of, I think negligence is probably the best way to put this, of the attorney that is representing the city of Harrisonville and the other appellants in this case is absolutely astounding. Now, there is a big difference between doing trial work and doing appellate work. Trial work involves planning for witness interrogations. You do depositions, you gather discovery, you respond to discovery. There are lots of mistakes you can make in that process, but most of them are recoverable. And most of the time when you make a mistake, it's not critical to the outcome. But in the appellate world, it's a lot different. And that is because by the time you get to the point of being an appellate judge, your level of patience with bad lawyering has reached pretty much its crescendo. And a lot of times you do see some really bad lawyering at the Supreme Court, at the appellate courts. I'll never forget, I was in an appellate argument at the Missouri Supreme Court. At the time, Judge Stephen Limbaugh was on the court, and he's now a district judge in the Eastern District of St. Louis in the federal system, but at the time he was on the Missouri Supreme Court. And he asked a question of a state appellate defender about jurisdiction. Now, this was a criminal case, and there really wasn't a whole lot of room to wiggle on jurisdiction. The court clearly had jurisdiction. But a lot of times a judge on the Court of Appeals or a judge on the Supreme Court will try to throw you a lifeline. They'll ask you a question to make you think and realize, hey, maybe you ought to adjust your argument a little bit. And if you, instead of thinking of it as a lifeline, you think of it as an anchor, a lot of times you're in trouble, and especially if you don't know how to answer the question. Every time a court has asked me a question at an appellate argument, and it's happened several times, where I did not immediately know the answer, and I didn't have co-counsel there that I could ask, well then, in those limited situations, I have said, Your Honor, I do not know the answer to that question, but I will find out and submit a letter to the court so that I can respond in an appropriate and professional way to something that, while embarrassing, is important. Unfortunately, in this case, when the judge asked him a question about jurisdiction, again, criminal case, he said, well, Judge, you say jurisdiction. I don't know what you mean. Do you mean in rem? Do you mean quasi in rem? Do you mean personal jurisdiction? Do you mean subject matter jurisdiction? And Judge Limbaugh looked at him and said, I was talking about the power of the court to render a judgment, which of course is the gestalt of subject matter jurisdiction. But instead of taking that lifeline, he just made a complete buffoon of himself, and of course he lost the appeal, as you might guess. But that's one of the problems that you face in appellate work. You have to submit a brief. You can't have 15 or 20 typos in it. You have to say things properly and appropriately. You have to cite authority that is current. And if you don't do that, you undermine your client's case and you damage your reputation as an attorney. So let's take a look at this case involving what I can only say is just a really bad job of briefing. Now, this case is the City of Harrisonville et al. Versus the Missouri Department of Natural Resources and the Board of Trustees for the Petroleum Storage Tank Insurance Fund. It's an appeal from the Circuit Court of Cole County, which is in Jefferson City. The city of Harrisonville and Brad Ratliff, collectively the city, appealed the circuit court's judgment overruling their motion for summary judgment and sustaining the Missouri Department of Natural Resources and Board of Trustees motion for summary judgment. The city's brief violates multiple provisions of Rule 84.04. Because these violations substantially impede appellate review, the appeal is dismissed. So before they ever get out of the gate, you have the court saying, not going to happen because you didn't know how to brief this thing. Now, a lot of times the lower courts, the Court of Appeals, will overlook briefing errors, but I don't even think the appellate court, the Western District in this case, would have overlooked these rather obvious and glaring errors. Apparently, the brief that was filed there met standards, but when you get a motion to transfer granted in a case, it's like the appellate opinion of the Court of Appeals just goes away. And by virtue of getting the case transferred to the Missouri Supreme Court, they can either rely on their brief in front of the Western District, or they can file a substitute brief. And the city here chose to file a substitute brief. Now, what's at issue in the actual case is really not that particularly important. The Missouri Department of Natural Resources is an executive agency. Carol Amy was the executive director of the fund, which is the Petroleum Storage Tank Fund. While she was director, the fund chairperson received a letter concerning Amy's conduct. The city filed a sunshine law request to MDNR requesting protection of the letter and any correspondence regarding the letter. So the city filed, basically the MDR produced some records, but not all of them. They filed a privilege log, and then the city filed suit against them, saying that they knowingly violated the sunshine law. The fund board intervened, and both parties filed motions for summary judgment. So the legal issues here are basically not that significant. The court finds the legislature intended to protect government employees' privacy rights, and the defendant did not commit a knowing or purposeful violation of the Missouri Sunshine Law. So what you have here is an appeal that would ask the court to interpret the Sunshine Law. So then we get down to the analysis. It says, Rule 84.13 provides, apart from questions of jurisdiction of the trial court over the subject matter, allegations of error not briefed or not properly briefed shall not be considered in any civil appeal. Now, shall not is a term of art. It means that you do not have the discretion as a court to entertain those errors. And unfortunately, the courts have been a little wishy-washy in enforcing this rule. As established below and required by 84.13, the city's failure to properly brief any allegation of reversible error requires dismissal. And so they start with the point relied on. The point relied on is a central, indispensable element of an appellate brief because it defines a specific issue for this court's review. And here's what they say about Rule 8404D. It requires the point relied on to identify the challenged trial court ruling, state concisely the legal reasons for the claim of reversible error, and 3, explain in summary fashion why, in the context of the case, those legal reasons support the claim of reversible error. And they say a properly drafted point is essential to this court because it notifies the opposing party of the matters which must be contended. And it says a non-compliant point relied on that fails to meet these essential purposes impedes the adversarial process and, by extension, this court's impartial review of a specific claim of reversible error. Because of the importance of the proper point relied on, the court has provided in Rule 8404 a roadmap enabling the appellant to draft a compliant point relied on by literally filling in the blanks to the following template. And here's the template. The point shall be substantially in the following form. The trial court erred in, and here you identify the ruling, because you state the legal reasons for the claim of reversible error. In that, explain why the legal reasons in the context of the case support the claim of reversible error. So let's take a look at a good point relied on. This is a point relied on from a case that I filed and that I was able to get a reversal on. And this is the actual point relied on. The trial court erred in entering a judgment of dismissal. That's the legal ruling that we're contesting, on the basis of forum nonconvenience, because the court never received any evidence of actual inconvenience in that defendant's motion. There is the legal reason why that is error. In that, defendant's motion was not verified, was not supported by affidavit, and the facts pleaded in the petition did not support the court's findings. So, you have one paragraph here that lays out the central claim of error that you're attacking. And then down below, it lists, for example, the different cases that are involved that support these claims of error. So, a deficient point relied on requires the respondent and appellate court to search the remainder of the brief to discern the appellant's assertion. If the court excuses an appellant's failure to follow this simple, mandatory format and attempts to discern some specific argument obscured by a non-compliant point, then the court abandons its role of neutral arbiter and instead becomes an advocate. It assumes an improper advocacy role on the appellant's brief. Not only that, but if it condones improper briefing, it also creates an unnecessary risk of deciding a case and establishing precedent based on inadequate briefing. None of the city's 3 points comply with the basic requirements. The city's first point states, the Circuit Court and Court of Appeals erred in closing the Walters letter pursuant to RSMO 61021 in that the Walters letter never related to the hiring, firing, discipline, or promotion of a state employee. Well, there's no judgment there that they have attacked. There's no claim, there's no ruling that the court made that you can identify from the rule. So it says it fails to identify the challenged circuit court ruling, and that's exactly correct. In addition to the failure to identify any alleged reversible error in the judgment, it's based on a non-cognizable claim that the Court of Appeals erred. And let me explain that too. The way it works in Missouri is when you file an appeal, you file it at the lowest appellate court unless it's specifically within the jurisdiction of the Supreme Court. So they would have filed this in the Western District Court of Appeals. The Western District Court of Appeals issued a judgment, and they said, we affirm. Now, if you disagree with that, you ask them first to reconsider it, and if they don't change their opinion, then you file what's called an application to transfer. You ask the Supreme Court to take on this important case. And once the Supreme Court says, yes, we will review your case, the Western District opinions has become a nullity. It doesn't exist any longer. It can't be published. It may still exist on like some of the computer services like Westlaw, but it will never appear in the Southwest Reporter, which is the official record of the courts of Missouri. So it's not going to be there. Everybody who does appellate work knows that. And you never make a claim that the Court of Appeals made a mistake in how it handled that particular issue. What you do is you take on a claim of trial court error, and you have to attack the trial court's judgment, not the appellate court's judgment. And that's essentially what they find here. They say, there is no appeal from a Court of Appeals decision. The Court of Appeals opinion is vacated when we transfer the appeal. To the extent the city purports to appeal from a circuit court's vacated decision, It's based on a fundamental misunderstanding of the appellate process and fails to state any cognizable claim of reversible error in the circuit court's judgment. Well, that's not good. So they lose on point 1. And then, like points 1 and 2, point 3 doesn't follow the template. While failing to identify any claim of reversible error in the circuit court's judgment, point 3 is dismissed. And the second point is similarly flawed. It says, again, the trial court's review was not a true de novo review of the circuit court's judgment, in that respondents did not submit all documents relied upon by the circuit court in rendering its judgment. Well, the respondents don't have to submit all of the documents. What the appellant has to do is the appellant has to put together the legal file, not the respondent. So if they did not complete the legal file, if the appellant here did not complete the legal file as they should have, again, that's not the respondent's fault, that's their fault. So I don't know whether this lawyer just was not familiar with doing appeals, maybe just tried to work from the real rule book, or maybe somebody was looking over his shoulder saying, just do this, just do that. I don't understand what happened here, but this could be the worst case of appellate briefing, particularly to be seen at the Supreme Court, that I've seen in a long time. So the court doesn't lightly dismiss an appeal, but there is a dissent in this case. And it says the dissenting opinion in Williams versus Hubbard is cited because the court there pretended the appellant did not file a substitute brief, despite Rule 8303 providing that if a party chooses to file a substitute brief, the substitute brief shall conform to Rule 8404, that it shall include all claims a party desires to have this court review. There is no denying this court failed to follow its own briefing rules in Williams and just reviewed the abandoned briefs that were filed in the Court of Appeals. So it gives the dissent basically a scattershot shotgun blast with regard to why it takes the position that it does. The court has an obligation to create and maintain a level playing field, and that requires adherence to the rules. And as a result, they cite a case from 1908 where they said these are not red tape. They have a purpose, and the obvious purpose is at getting at the right of a cause. So getting it right is important. If they're not obeyed, they should be done away with once and for all. But they do need to be obeyed. Furthermore, even if this court were to review the city's appeal ex gratia, meaning out of the goodness of their heart, the circuit court's judgment would be affirmed because the city's non-compliant points relied on only purport to appeal the summary judgment based on Section 3 and not subsection 13 of the statute, and summary judgment was granted on both sections. The law is clear: when the circuit court does not state the explicit reason for sustaining a motion, appellate courts presume it was based on the reasons set forth in the motion for summary judgment. So again, a huge error on the part of these lawyers in the briefing. Because all the city's points relied on are fundamentally non-compliant, we dismiss. Now, Ransom and Broniak concur. Powell concurs in part with Section 2 of the principal opinion. Wilson dissents in a separate opinion filed. And Russell concurs in the opinion of Wilson. So this is really interesting because Judge Wilson is usually a stickler for the rules. He dissents, and he does so because it's unnecessary and out of step with the court's precedent. The city's substitute brief is unhappy with the result of the Court of Appeals, filed an application to transfer. Essentially, what Wilson is doing here is just glossing over all the errors. It looks to me like the Supreme Court made the right decision, and one of the reasons it made the right decision is because appeals require a lot of adherence to doing the job the right way, and if you don't do the job the right way, then again, you impede this legal process of getting an appellate review. So that's what I have for you today. It's not, it's not the Brown versus Board of Education, but it is important, I think, because it illustrates the fundamental difference between appellate lawyers who are obviously stuck with the rules that they have, and they have to play by the rules, and they have to play strictly by the rules, and trial court lawyers who are essentially people who argue cases, examine witnesses, and do all that kind of thing. Those are two separate skill sets. You get both of those skills in law school, but after you leave law school, it's a use it or lose it kind of thing. And, if I were to try to do a deposition at this point, not having done one in, I guess I did one 3 years ago, it's hard. I mean, it's really hard to go back and put yourself in that mindset. And it's also hard for somebody who's never done an appeal to do an appeal the right way. So hopefully this has been interesting, maybe just a little bit funny. Again, the lawyers here are not ethically challenged. They didn't violate their ethical code. They just were negligent in how they put this brief together, which is odd considering that their client was a city in the state of Missouri. Thank you so much for watching. If you have the opportunity today, go out and do something nice for somebody. You'll enjoy the day a lot more if you do. And then come catch me down here at the beach again tomorrow. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.